Today's video, I will shed some light on how to claim work experience points for skilled visas. Hi, welcome to Newstars Immigration International channel. Newstars has over 15 years experience in the immigration industry. Newstars is made up of a team of more than 20 migration agents and immigration lawyers who all share the same passion and knowledge for helping people like you to migrate to Australia. I'm Jack, who is a registered migration agent and also a lawyer admitted in the Supreme Court of New South Wales. Have you ever thought that maybe you have not claimed the points for your skilled visa, but actually you are eligible to claim? This mostly happens when it comes to work experience points. If you are applying for the 189, 190, or 491 visas, you need to meet a minimum score of 65 points on a points test. In reality, the more points you gain, the better chance you will be invited for applying for these kinds of visas. The Australian government sets a maximum intake of immigrants each year, and it's significantly cloudy to get a visa. One section which you may claim points is via your work experience, if it's in your nominated occupation or one that is closely related. Basically, closely related occupations are in the same group on the NCCO website, and occupations with identical four first digits are within the same group. For example, accountant and taxi agent accountant are within the same group, so they are closely related occupations. Obviously, the more years of experience you have, the more points you obtain. It seems to be self-explained legislation, but it does not clearly state which kind of work experience can be counted. I'm always amazed about how many people I consulted are not claiming all the full amount of work, and some of which are overclaiming work experience, which can't be counted towards a skilled visa. One of these reasons that this happens is because there is lack of understanding of what a closely related occupation is, and they did not end up claiming points for occupations that would in fact qualify as closely related. Another key reason for many skilled migrant applications missing out potential points is due to some skill assessment authorities giving misleading advice. When you obtain your skill assessment outcome, you will notice that there is a term called dated deemed skilled or skilled requirement met date. This is the date by the skill assessment body that tells you when you were qualified or at the skill level requirement to work in your nominated occupation. By this term, you might have thought that you can only claim work experience after this date. But in fact, these deemed skill dates can be quite misleading when it comes to how many points you could claim on the points test. Let's have a look at the policy manual which the Immigration Department decision maker must refer to. It states that if the skills assessing authority's opinion would result in the applicant being awarded less points than claimed in their EOI, then decision makers should consider the information in the NCCO and apply the more beneficial outcome in determining whether an applicant was working at a skilled level. The primary legislation requires only that the applicant is employed in a nominated skilled occupation for a particular period of time. The provision does not require the applicant to have the skills of a particular standard during that employment. The decision maker can consider whether the applicant is undertaking at least some of the duties prescribed for the position in NCCO. For instance, if a client is claiming employment as a cook, the tasks they are undertaking those of a cook. Here are some examples. The Australian Computer Society tells IT professionals with a degree qualification from overseas that they need a specific years of experience before they reach their skill level in an occupation. For example, an applicant who has an overseas bachelor degree in IT generally needs a further 2 years of experience to gain a positive skill assessment. The skill assessment result indicates that those 2 years of work experience do not meet the skill level required to claim points under the points test. However, this is not accurate. You can claim of these points of 2 years of work experience points because the ethical description says only a degree is necessary to meet the skill level, not the extra 2 years of work experience. Another example is Vietnamese. Vietnamese says carries out their skill assessment process for immigration purposes if you have highly relevant minimum qualification level for your occupation. Then you generally only need 12 months of work experience to qualify for your skill assessment. They also say that you can claim experience only after this skill level has been obtained. Again, this is misleading because the immigration department policy is that you can claim all of your experience points after the time you have met the minimum qualification level as outlined in article. Because of these discrepancies and information, too many people end up not claiming all the points they could claim, based on some skills assessment body giving outdated advice. It would be better to refer to the immigration department's primary legislations rather than what a skill assessment body tells you. If you have any questions in this issue, please book a time and discuss your circumstances so we can give you accurate and tailored guidance. Alright, that is all the content for today's video. Don't forget to subscribe and like our video to support this channel. And always take care there, and I will see you next time. So bye now.